Hello, everyone, and welcome to Uncivil Law. I hope you're having a really great day today. We are here with Supreme Court React time for a case argued this week dealing with the retroactive effect of criminal proceedings. And so I need to just quickly ping everyone to let them know that we are going live. Yes, great. So anyways, we're here to deal with the retroactive effect of Supreme Court decisions on criminal cases. So long story short, under current law, most Supreme Court decisions that come up in a habeas context are not retroactive. So if you are appealing your own case and you go through the normal process of trial court, appellate court, Supreme Court, those would be retroactive. But a habeas review is considered a collateral attack. It's not the normal appeal process. So a collateral attack is when you come at a case from the side. You attack it not by direct appeal, you attack it, horizontally, if you like. So when you go from trial to appeal to Supreme Court, that's vertical. That's in the same case. When you come with a habeas petition, you're coming at from the side. So it's a different case. It's collateral attack because you're coming at it horizontally. And so the normal rule is that in habeas petitions, whatever rule you come up with is not retroactive. So that brings us to the normal case at hand that we have. Habeas is habeas corpus. It is called the Great Writ in the Constitution. Literally means produce the body, but figuratively means provide the rationale for why a particular person is being held. So if you are being held unlawfully, you bring a habeas petition. So your argument is that you are being held unlawfully, and so it's a way of collateral attack to literally bring the person before the court so that they can justify why you're being held. So that's a habeas corpus review, and they're used in criminal cases if you're being held, and to show why or civil cases for that matter too, if you're being civilly committed, to show why the justification is for you being held. So anyways, we're here on the case of Randall Mathena, the warden, versus Lee Boyd Malvo, the prisoner. This deals with the D.C. Stipers cases that we all may remember from 15 years ago. Malvo was the juvenile who was going in a van from place to place and shot and killed quite a few people, as I recall. I forget exactly how many, but multiple murder counts. And he's been in jail ever since on a life sentence without the possibility of parole. Now, sometime after this case became final, the Supreme Court, in an unrelated case, decided that life without parole for juvenile offenses was unconstitutional. That because of the nature of juveniles and the brain and their brain development, that was unconstitutional. The question then becomes the retroactive effect of that decision to other cases that were final at that time. And so it was deemed, and that is one such case where this is being dealt with. So his case was already final. He had already lost all his appeals. So he came out with a habeas petition basically saying this rule should be applied to me. The lower court said that you're right, it should be applied to him, and it's being appealed on the issue of whether or not it should have retroactive effect or not. It won't matter very much because, he has multiple different life sentences, but it will have impacts on other cases. So it won't do much good to Mr. Malvo either way, because even if he has to be resentenced, he would have multiple counts. So he's never going to see the light of day ever again, I'm sure, no matter what the Supreme Court does, but it will have impacts for other cases. For juveniles who currently are sitting on a life sentence without possibility of parole, whose cases have been come final, and whether or not they have an opportunity, because that has now been deemed to be unconstitutional. Should that decision retroactively apply? Should it apply going backwards? Most decisions apply going forwards. So should this decision go backwards? So this is basically the question here. Should the prior decision dealing with the constitutionality of putting juveniles in life without parole, should that have retroactive, backwards-looking impact? So we're going to listen to the arguments and react and see how it goes. So let's get started. Should be entertaining.
We'll hear argument next in Mathena versus Malvo. Mr. Heitens.
Mr. Chief Justice, and may it please the Court. 15 years ago, Lee Malvo was tried, convicted, and sentenced for his role in the D.C. sniper attacks. Almost a decade later, Malvo sought federal habeas relief, relying exclusively on the new rule announced by this Court in Miller versus Alabama. But Miller's rule does not cover Malvo's case, and the lower courts erred in holding otherwise. I'd like to make 3 points, one about Miller, one about Montgomery, and one about why this matters. First, if Miller's holding isn't concerned with mandatory sentences, much of this Court's language in Miller makes very little sense. Miller repeatedly stated its own holding in terms of mandatory sentences, and the Court's analysis specifically distinguished between mandatory and non-mandatory states.
All right, so far what he's saying is the prior case Miller is the prior case dealing with the constitutionality of sentencing juveniles to life imprisonment without parole. And they say that there is a distinguishment in Miller, according to him, between mandatory sentences and non-mandatory sentences. So some cases, the statutes are written such that if you commit certain crimes, it's mandatory sentence and there's no discretion. In other cases, it's an option that's available to the court. So he's saying it only applies in situations where it's mandatory. If you have more than one option, the analysis doesn't apply. So he's saying that this case doesn't even make sense under the precedent because it was a non-mandatory case. So let's go on and see what else we have.
Second, Montgomery must be interpreted both in light of Miller and in light of the facts that were before the court. All of the defendants before the court in both Miller and Montgomery had received mandatory sentences, and this court should not lightly interpret a decision about retroactivity as having retroactively announced a new rule governing non-mandatory sentences. Finally, the reason why habeas is so formal and restrictive is because habeas is extraordinarily costly. Malvo's victims were already required to endure one full trial and sentencing hearing more than a decade ago, and the court should not lightly ask them to go through another, particularly given that the original sentencing fully complied with then-controlling constitutional restrictions. I waive the remainder of my 2 minutes. So turning to the...
So just FYI, because I did not know this when we had our last discussion on the issue, because it's a new rule that just announced. The Supreme Court, for this term, for the first time ever, as far as I'm aware, put in a rule that said for the first 2 minutes of an oral argument, they're not going to interrupt you. This is a new thing. This is a brand new thing that I never heard of before, and it's a really interesting idea. But so now you get 2 minutes for free, and he just said, I waive the remainder of my 2 minutes, basically saying, I'm giving you permission to ask me questions at this point. Okay, it's a brand new rule, so why not? Sure, why not? Fine.
First point about Miller. I think it's just extremely hard, as Malvo's brief now clarifies, that he only sought habeas relief based on Miller. And if you look at Malvo's original habeas petition, it's on page 80 of the petition appendix, he doesn't just say that he's seeking relief based on Miller. He says he's seeking relief based on Miller's holding that mandatory life without parole violates the Eighth Amendment. So I think even Malvo, when he originally sought habeas in this case, recognized the precise nature of Miller's holding, and I think it's extraordinarily hard to get away from that.
Mr. Heitens, could we back up a little and explain to me why these sentences are not mandatory? I mean, the jury had only 2 choices, death or life without parole. And nobody seemed to have appreciated at the time of Malvo's convictions that there was any discretion. And the piece of information I'd like to have, has any Virginia judge ever reduced a juvenile life without parole to life with parole or a term of years?
Justice Ginsburg, I am not aware of any Virginia judge ever reducing a juvenile life without parole sentence for a person convicted of capital murder, which was the offense that Malvo was convicted of. I believe that's factually true, that I'm not aware of an example. There have been examples of Virginia courts considering whether to do so, although those long predate Malvo's. I acknowledge that those post-date Malvo's sentence. To go to your question about what the jury was instructed, that is what the jury was instructed, but Virginia law is extremely clear that the sentencer is not the jury. The sentencer is the judge. And under the Supreme Court of Virginia's holding in Jones 2, which Malvo does not and cannot challenge, this trial judge had the authority to suspend the sentence as a matter of state law. And not only had the authority to do it, but had the authority to do it at the time of Malvo's trial. That's the specific issue that the Supreme Court of Virginia addressed in Jones. And I think that's a binding holding as a matter of...
Well, that's a pretty thin slice to get in. The idea that a judge could suspend the sentence as basically in the interest of justice. I know New York has this explicitly in their code, and Virginia apparently has the same doctrine, not explicitly in its code, but the idea a judge can suspend the sentence. So he's basically saying, hypothetically, the judge could say, well, even though the statute says my choices are death or life without parole, and you're a juvenile, so we can't give you death, therefore my choices are life without parole. Still, notwithstanding that, I can still say that I'm going to suspend your sentence and not give you any jail time. Well, notwithstanding whether a judge can do that, there's no way on God's earth that a judge would do that in this circumstance. The guy was most decidedly guilty of multiple murders. This is not some sort of, one in a bajillion case where that kind of rationale would be logical. So hypothetically, maybe a judge could do it, but to say, well, that makes it non-mandatory, it's like, all right, that's slicing it pretty thin. I admire your creativity, but I don't think that's going to really work. Just a few other comments. Seindinger said, it seemed fair to allow one to speak to lay the groundwork. Yeah, I agree. I like the new rule. The Supreme Court said you get 2 minutes for free. So I like the new rule. And also, they also put a new rule in this term that you don't have to explicitly reserve your time anymore. So we didn't hear him say, I reserve X amount of time at the start of his thing, because you used to have to do that if you want to reserve time. Now you can advise the clerk in advance. You can reserve up to 5 minutes, and they'll just adjust the time for you. So you can just slip them a note, and so you don't have to do it on the fly anymore. So that's kind of cool. So you get 2 minutes for free, and you don't have to remember to ask for rebuttal time. You can just ask for it in advance, and they'll reduce your time up front 5 minutes and give you 5 minutes on the back end. So that's pretty cool. But yeah, to say that makes it non-mandatory, that's a pretty thin slice. On one level, I admire the lawyer's creativity, but that's not going to fly. Yeah.
The judge know he could, given that there was no history of doing it. I think that's the position of the SG in this case. But more fundamentally, the Fourth Circuit concluded, I quote them, Malvo's youth and attendant circumstances were not considered by either the jury or the judge to determine whether to sentence him to life without parole or some lesser sentence. Do you disagree with that statement?
I think it's very hard to tell based on the record whether they were. I think the fairest description of the record is that there is no affirmative indication one way or another.
All right. So tell me what the practical effect is, or why Montgomery and its language would have drawn a difference between a juvenile who was not sentenced to death because he was not incorrigible and a youth who under a discretionary sentence was sentenced not to death, to life without parole, even though the judge didn't think he was incorrigible but thought the crime was horrible. So that really is the nub of this case, which, given the language of Montgomery and Miller, does it make any sense to treat either of them differently?
So Justice Sotomayor, I think the first thing I'd say to that is I don't think that for Teague purposes we can say given the language of Montgomery and Miller. I think we need to be
So Teague is the name of a case that deals, it's called Teague v. Lane. If you want to look it up, that is sort of the parent case that deals with retroactivity effect of criminal sentences. So that's the big case that sits about retroactive effect. These other cases, Miller and Montgomery, are dealing with more specific scenarios in which Teague is the parent case. So those are those cases. What are they discussing now? They are discussing whether or not the Supreme Court's decision that juvenile sentences cannot be life without parole should have retroactive effect or not as it applies to the DC sniper. That's the question at hand. The DC sniper was 17 at the time. He's been in jail 15 years. He was given multiple life sentences without parole. That has since been found to be unconstitutional. The question is whether or not that should have retroactive effect as it exists to him or not. And so far, the government is not doing a fantastic job because they're having to slice this pretty thin. This is not going to work. It's well done. It's just, unfortunately, it's a very, very thin slice argument. So it's slicing it too thin. I don't think it's going to fly.
Very specific where the rule that we're talking about is coming from. And to address your question of what's the difference, I think the difference is stated in the last paragraph of the Miller opinion, where the court fundamentally identifies the problem with the scheme invalidated in Miller. The court said that the sentencer was deprived of, quote, the opportunity to consider youth and its mitigating factors, and instead that the states at issue in that case had required
yes, this is state of Virginia,
that all
yes.
children receive life without parole sentences. As a matter of Virginia state law, that was not true here.
General, this is maybe Justice Sotomayor's question phrased a little bit differently. Of course, Miller talks about mandatory schemes a lot because Miller was about a mandatory scheme. But do you think after Miller, in a state where there was not a mandatory scheme, a judge could say, you know what, I just don't feel like thinking about the defendant's youth. I don't think it's remotely relevant, and I'm going to just sweep away anything that the defendant presents to me about that. I couldn't care less. Do you think that that's permissible under Miller?
Justice Kagan, I'm sorry. I don't think that would be permissible, but I think we need to distinguish between why that's not permissible. I think as a matter of the Eighth Amendment, that's not permissible, but I think the articulation of the cases following Woodson and the death penalty illustrate why that is a new rule for Teague purposes. So I think that if a court were properly presented with that argument after Miller, it should hold that that's an Eighth Amendment violation, but I think that would be a new rule for Teague purposes, and the way I know is how this played out in the capital context, right? So the court first decides Woodson, which deals with a mandatory death penalty, very similar to Miller. And then the court has a whole series of cases after Woodson, some of which really are very close to what you said, Justice Kagan, where the sentencer is not formally required to impose death, but says, I'm not going to consider youth. And the court, in later cases, said that also violates the Eighth Amendment. But there was no suggestion that would...
I mean, I guess what you're saying is that it would take another case to make that clear. But I think Miller itself makes that clear. If there's anything that Miller says, I mean, all of Miller, it's a 30-page opinion, and it can be summarized in 2 words, which is that youth matters.
Yep.
And that you have to consider youth in making these sorts of sentencing determinations.
She's right.
And again, of course, it talks a lot about mandatory schemes because a mandatory scheme was in front of it. But the entire reasoning was about how much youth matters and how a judge or a jury, whoever the sentencer is, has to take that youth into account. That's the lesson of Miller.
I 100% agree with Elena Kagan's categorization of the case, that it can be summed up into youth matters. I think that's a very fair characterization of the case. It has to be considered as a factor in the case when being considered sentencing, as a relevant consideration. And she's saying, look, all this language that dealt with mandatory is basically irrelevant. It didn't turn on that. It turned on the fact it was juvenile. Yeah, they talked a lot about mandatory because the issue at bar, at the case, was dealing with a mandatory sentence. So, of course, they talked about mandatory because it was relevant to that particular case. But it's not relevant to the rule of law. The rule of law doesn't turn on mandatory, according to Kagan. It turns on juvenile, fact that youth matters. I think Kagan is correct in her summary of the law. So let's carry on.
So two responses to that, Justice Kagan. First, I do want to differentiate because I think the habeas context matters here. I agree with you that after Miller, the right interpretation of the Eighth Amendment is that the thing you describe would violate it. But I think under this Court's Teague jurisprudence, that doesn't resolve the question of whether Decision 2 is a new rule. I mean, the Court has said ever since Teague that the definition of new rule is extraordinarily broad and includes anything that is not dictated by the earlier decision. And I just don't see how one can read Miller and conclude that a decision that describes its holding in terms of mandatory sentences dictates that Virginia's non-mandatory.
So I think
I don't buy that argument for 1 second. I really don't buy it. For 1 second, he says, I don't see how one can read Miller and conclude decision describes its holding in terms of mandatory sentences dictates Volder. But he himself says it's only a new rule if it includes anything that's not dictated by the earlier decision. The fact it was mandatory did not dictate the decision. I think Kagan's right. It didn't dictate the decision. The fact it was a mandatory rule was ultimately irrelevant to the case. The fact that mattered was that it was a juvenile. And so by his own reasoning, it's not a new rule. So he's fighting precedent, and he's making a really hyper thin argument, and his reasoning doesn't really follow. He's doing a good job making a very thin argument, but it's not persuasive.
We're just going to posit that I disagree with that. But suppose I didn't disagree with that, then you also have to deal with Montgomery, because that's the way Montgomery reads Miller. And Montgomery says that's what Miller said. It's not some later new rule. That's the rule from Miller, says Montgomery.
I certainly acknowledge that Montgomery says that, Justice Kagan, but I don't think that's controlling for Teague purposes, and I think the Court has specifically actually confronted a case quite similar where that happened. The case, this is cited on page 17 of our brief, it's Butler versus McKellar, where a very similar argument was made and rejected in the habeas context. So that case, the first case was Edwards versus Arizona, the one that says that when the defendant says he wants to talk to a lawyer, police can't go and talk to him without getting him a lawyer. And then 7 years later, the Court in Arizona versus Roberson says that is true even if the thing you want to go back and talk to him about is a different crime. And in Roberson, the Court said, quote, our decision is controlled by Arizona versus Edwards. And then in Butler, in the habeas context, the Court said that was a new rule for Teague purposes. I just think that the argument that Montgomery clarified or confirmed or any of the language that the Fourth Circuit or the District Court...
I'm sorry. We couldn't, under Teague, have made Miller retroactive unless there was both a procedural and substantive rule. And so whether or not there are people who misread Miller or not, some courts did, a lot didn't. The substantive ruling of Miller was very clear that it rendered life without, I'm quoting it, parole an unconstitutional penalty for a class of defendants because of their status. That is, juvenile offenders whose crime reflect the transient immaturity of youth. It says, Miller announced a substantive rule of constitutional law. So it's not a new procedural rule. Mm-hmm. It is an old substantive law that it's embodying. That's the distinction that I don't see. Your case, the one you cited, was applying it, not reading the old case. It was announcing a new take of that. Montgomery said, we're telling you what Miller said.
Justice Sotomayor, I certainly don't disagree that there's language to that effect in Montgomery, but I think it is important that that language that you just quoted is virtually all from Montgomery and appears nowhere in Miller, except for a few words that are sort of included in that very long quote.
Suppose I try to read Miller and Montgomery together to figure out what the substantive rule is, and that I conclude the substantive rule is that the state cannot impose life without parole on youth who are merely immature, but can impose it on those who are incorrigible. Okay, suppose that's the substantive rule. I suppose Miller and Montgomery, then we have to figure out what the procedural rule attached to that was.
Correct.
The procedural rule attached, you can read it in a couple of different ways, so I want to get your thoughts. One is it rules out an on-the-record finding. right? Montgomery says you don't have to make a record finding of incorrigible. It's explicit about that. The question then for me comes down to, is a discretionary sentencing regime alone enough to satisfy the procedural requirements to implement that substantive rule, or does there have to be something more on the record stated by the sentencing judge about youth?
Justice
So the question is trying to distinguish between substantive rules and procedural rules, which does go to retroactive effect in terms of different procedure versus different substantive rules. So substantive rules tend to have more retroactive effect than procedural rules for very obvious reasons. So he's saying, well, some of this is substantive, but what procedure is necessary to give that substance? So he's like, is it enough to consider this or not? So it's like, okay, carrying on. Yeah, Lynch says he seems a little bit more full than the Title VII anti-lawyer. I would agree fully. I would agree this lawyer is way better than the Title VII lawyer that we discussed, and who, when we spoke, we wanted to all like beat our heads against the wall. This guy is very competent in what he's doing. He's making a very, very tough argument because the case law is sitting against him. So he's having to make this very thin slice to make this work. But he's doing it competently, so you can't blame him for not being competent. He's very competent. He's making a cogent argument. It's just slicing it so thin, I just don't think it's going to fly.
Well, no, I think certainly in the habeas context, that satisfies the holdings of Miller and Montgomery. Now, whether the court,
that being a discretionary sentence.
I'm sorry. Yes, I apologize.
And why is something more procedurally not required? We know a finding of fact is explicitly ruled out by Montgomery, and that's very important. But why isn't something more than just a discretionary sentencing regime necessary?
Well, I think particularly because of the habeas context. So I don't want to rule out the notion that the court couldn't, in the further elaboration of the Eighth Amendment, require such a thing. But I think in the habeas context, what's critical is that this trial and sentence occurred long before either Montgomery or Miller, and the court has emphasized that particularly in the
not
habeas,
a bad argument.
Teague is not restrictive for the sake of being restrictive.
Let me ask it this way.
Okay, so that's actually a pretty interesting idea. So he's saying the case occurred before either Miller or Montgomery, and therefore those cases should not have retroactive effect in and of themselves. That's actually a pretty interesting substantive constitutional argument. It's the best argument he's made so far, actually. He's saying this case occurred before those rules even existed. So, like, even though those cases say when to do retroactive effect, they were not in effect at the time. So that's actually a pretty good constitutional line. I still don't think it's going to work, but it's a better argument.
I think a discretionary sentencing regime is enough to satisfy the substantive Miller-Montgomery rule, as I posit it, that you can't impose life without parole on someone who's merely immature as opposed to incorrigible?
I would say that under existing law on collateral review, yes. I would.
Even if you know for a fact that the sentencer did not take youth into account?
Well, Justice Kagan, I guess at first I would...
It's a discretionary system. The sentencer could have taken youth into account, but he didn't.
Well, Justice Kagan, I just want to make sure if this is a hypothetical or if you're asking about the facts of this case.
No, it's the hypothetical.
Okay, I just want to make sure because my answer would be different depending on...
I have a follow-up hypothetical to the hypothetical.
Okay, so if you know for sure, say because the sentencer specifically says on the record that they didn't, I think for purposes of federal habeas review, the answer is still that is not a cognizable basis for retroactively invalidating a conviction. I think on direct review, I think that person would have a very strong argument. I suspect that I would think that person's going to have the better of the argument, that the person's going to win. But that's because the way the court's cases develop is in a piecemeal fashion.
Okay, now suppose the record does not have what Justice Kagan posited. The record as it is in 99.99% of the cases is youth is raised by the defense counsel, and the sentencing judge either says nothing, just imposes the sentence without explaining anything about youth, or just discusses youth but says ultimately still going to stick with life without parole. So in that circumstance, is that enough?
Yes. And the reason is because as we explain in our...
How do we know, and this is the tough part of the case for me, it's right on this, how do we know in that circumstance that the sentencing judge separated the incorrigible from the I'm using these phrases shorthand,
Sure.
the merely immature.
I think the best way we know that is because, as our brief and the state's brief explains, in every single state that has a discretionary sentencing scheme, the sentencer is specifically instructed to consider age. And I think the court, particularly in the habeas context, can presume that judges follow their obligation under state law.
Is this one of those states where the sentencer is given a list of criteria that he's supposed to consider?
Yes, the Supreme Court of Virginia in Jones 2 specifically articulates the factors that sentencers are supposed to consider, including in deciding whether to suspend a sentence, and one of those factors is age.
If I
It specifies in considering whether to suspend a sentence?
I believe it does. This is again, from the Supreme Court of Virginia's decision in Jones 2 that responds to this court's GVR in light of Montgomery, and I believe they specifically say as a matter of state law, yes.
Jones 2 was many years after this sentencing took place.
Yeah. Absolutely, Justice Kagan, but Jones 2 critically did not purport to change or alter what Virginia law was. All of the statutes that are discussed in Jones 2 were on the books at the time of this sentencing. It's not like Virginia changed its law after its sentencing.
What if we were unsure about that? Shouldn't we even if you were correct on the law here, isn't there still a question of whether Virginia's regime was truly discretionary?
I don't think
or do you think that's over?
I apologize, Justice Kavanaugh. I think the Supreme Court of Virginia was very clear in Jones 2 about that. Thank you.
Thank you, counsel.
17 minutes. I don't think it's a very persuasive argument. I think it's slicing it too thin. I don't think this is going to work. We'll see what else we have, but so far I'm thinking that the state's not going to win this argument. Let's carry on, though.
Mr. Fagan?
Thank you, Mr. Chief Justice, and may it please the Court. Malvo is arguing that his life without parole sentences for his murders are retroactively invalid under Miller, even if Virginia law allowed him to seek a lower sentence based on his age. That's wrong for two reasons. First of all, the substantive retroactive holding of Miller is limited to mandatory sentences. Any objection Malvo has to the particular sentencing proceedings in his individual case would at best fall under what Montgomery describes as Miller's procedural component, which isn't retroactive. Second, all that procedural component requires is the opportunity to raise age as a reason for a lower sentence. Neither Montgomery nor Miller prescribes a precise formula for taking age into account, let alone requires a sentencer to consider age even when a defendant himself fails to put it at issue. Now, Justice Kavanaugh, you asked how we know that a discretionary scheme, the existence of a discretionary scheme, is sufficient to protect against the substantive right that Montgomery finds that Miller recognizes. I think we know that from a couple of different places. First, in Miller itself, I think the Court goes out of its way to compare and contrast discretionary schemes and mandatory schemes. I think you'll find this in particular at page 484 of Miller, noting that basically, as I read Miller, discretionary schemes are generally getting it right and mandatory schemes aren't. And I think it would be quite surprising that the kind of scheme the Court used as its baseline for comparison turns out, in fact, to be unconstitutional. But the second place we know it, I think, is from page 734 of Montgomery, where the Court says that the ability, and you combine that with page 735 that makes clear it's the opportunity to consider age, that the procedural component of Miller, which is the opportunity to consider age, is what protects the substantive right. And if, as the Fourth Circuit supposed and the Virginia Supreme Court held in Jones 2, Malvo actually did have the opportunity to seek a lower sentence based on his age, then I don't think he can recast his claim as a substantive claim under Miller that he had his substantive rights violated.
And his opportunity came from what?
So his opportunity came from the fact that the Virginia Supreme Court, again, Your Honor, we're not taking a position on whether this should, in fact, be considered a mandatory or discretionary scheme under Miller. We are just assuming, along with the Fourth Circuit, and I think as Justice Kavanaugh's recent questioning got at, we do think this should be remanded if the Court agrees with us for some further exploration of the nature of Virginia's scheme. But assuming that this was a discretionary scheme, Jones 2, the Virginia Supreme Court's decision in that case, says that a defendant in Malvo's position, and Jones was, I think, similarly situated to Malvo in this respect, was able to seek suspension of all or part of his sentence on any ground, including youth. And if that is correct, and if that is sufficient for a scheme to be considered discretionary under Miller, then I don't think he has a claim under Miller.
So one thing I want to take note of here that he said that I think is really interesting. He said that we think it should be basically remanded for some discussion on whether or not it was. He says it should be remanded if the court agrees with us for further explanation of the nature of Virginia's scheme. So he's basically offering the Supreme Court an out. He's basically saying you don't have to decide this case. You can send it back for further discussion on whether or not it was mandatory or not mandatory within the meaning of this, and so you can avoid the issue for another day. So he's giving him an out to say you can remand this for further factual considerations. I don't know if the Supreme Court will take him up on it, but it's a very clever move to say there's a way for you to deflect this. So that's pretty cool. Noted.
What he might have, I suppose, is a very untimely, ineffective assistance of counsel claim, although I'm not even sure he would succeed on the merits of that. But we don't usually excuse defendants from their failure to raise particular considerations and decide that their substantive rights have been violated for that reason. As Justice Kavanaugh noted, in 99.9% of these cases, youth is going to be raised, and that's because everyone realizes that youth is important when you are sentencing someone to life without parole.
You want us to hold that a discretionary regime satisfies Miller and Montgomery and remand for consideration of all these things, forfeiture, whether it was really discretionary.
That's correct, Your Honor. That's our only submission in the case, is that you should reverse the Fourth Circuit on its view that even if, contrary to the Virginia Supreme Court's view, even if, consistent with the Virginia Supreme Court's view, this is a discretionary scheme, then he would have a Miller claim.
But again, and this is...
So that's interesting. The Virginia Supreme Court said they consider it to be a discretionary scheme already in this case. I wonder if that is dispositive. My natural answer would be to say it's dispositive because Virginia Supreme Court is the ultimate judge of its own laws. So if Supreme Court of Virginia said it's a discretionary scheme, that might be the end of that analysis as far as that go. Maybe the right conclusion is, as a matter of law, it is a discretionary scheme because the Virginia Supreme Court said it is. So even though no one would ever use the discretion, it technically qualifies as discretionary. I'm not 100% sure the U.S. Supreme Court can reverse that decision because Virginia is interpreting its own laws to say there is this discretion. So it might be a discretionary scheme. Now, of course, that only matters to the extent that the prior case was relying on the fact of the non-discretionary scheme as part of the rationale of the case. But I don't think it's part of the rationale of the case. So I don't think it really matters either way, whether it was discretionary or not. Even if it's discretionary, if it wasn't factored in, then Virginia would have to go back and do some further sentencing. So I'm not sure it matters that it's discretionary, but I don't think the Supreme Court can actually reverse that part of the decision. I think that might be a legally binding conclusion on the U.S. Supreme Court. Interesting.
It's the same question that I asked Mr. Heitens. If it's a discretionary scheme, a judge could simply say, well, I don't think that consideration matters at all. I refuse to consider it. And you think that Miller does not have anything to say about that?
No, I think our answer to that is a little bit different from General Hyten's answer. I do think Miller, as it's currently written, and Montgomery would say that a procedural right has been violated in that case. But what we have here is a question of retroactivity. And that's a procedural, what you're talking about is a procedural right that I think Miller does require at least the opportunity to consider age. And given its analogy to cases like Eddings against Oklahoma and Lockett against Ohio, I think the sentencer can't decide that legally youth has no weight.
Right. So let's assume that. And in fact, Miller says several times, not just requires an opportunity to consider, but requires consideration. And then what Montgomery does, as I understand it, is Montgomery makes clear that that procedural requirement is in service of a substantive requirement. In other words, it's in service of a substantive rule, and that rule is the one that Justice Kavanaugh made reference to, which is the rule that the irretrievably corrupt and only those people can be subject to life in prison without parole. So the requirement of consideration is in service of the substantive rule that says, except for the irretrievably corrupt, you can't sentence a juvenile to life without parole.
So, Justice Kagan, let me give you the sort of short answer to your question, then I have a slightly longer answer. I think the shorter answer to your question is, yes, the procedural right protects a substantive one, but because it's a procedural right, it's not retroactive. The only thing that is retroactive under Montgomery is what Montgomery describes itself to be considering, and this is on page 732, is it says that what it's considering is whether Miller's holding that precludes mandatory sentences of life without parole for juvenile offenders is retroactive.
No, Montgomery says Miller's holding that only the irretrievably corrupt can be sentenced to life without parole. That's what Montgomery says. And that's, in fact, it's taking language from Miller and saying that's the substantive rule that comes out of Miller, which is this distinction between those who commit crimes based on transient immaturity, blah, blah, blah.
So this gets at my somewhat longer answer, Justice Kagan, which is that, as we acknowledge in our brief, I think it's very difficult to completely square some of the language in Montgomery with the language in Miller, which I think is very clearly focused on mandatory sentences. And to the extent that the court has to preference some language over other language, we'd urge the court to preference the language that adheres to the common scenario in both cases, which involved only mandatory sentences.
So he's making fundamentally the same argument the first attorney was in a lot of respects, right? He's saying the prior cases, well, they're making two arguments. He's saying, first of all, the rule that was announced is procedural, not substantive, and therefore it doesn't have retroactive effect. I don't think that really works because the procedure is in service of the substance, but the substantive rule has to have some procedure to it. And so unless you can show there was a procedure at the time that gave effect to the substantive rule, which would be hard because the substantive rule didn't exist yet, then the fact that the procedural aspect is not retroactive is kind of irrelevant because the substantive aspect is retroactive, and that has not been given procedural effect either by the procedure as it now exists or a procedure at the time, because again, the substantive rule didn't exist. So how could a procedural rule exist? I guess it's hypothetically possible, but I don't really see it here. So that's one argument they're trying to make, is that it's procedural, not substantive. I don't think that argument's going to fly. The other argument they're trying to make is this whole thing about mandatory versus non-mandatory, discretion versus non-discretionary sentences. So what they're saying is if the life without parole was a mandatory sentence, non-discretionary, the court had to do it, that's one rule. On the other hand, if it's just an option, then that isn't covered by the prior cases. And so he's trying to say the prior cases, the mandatory aspect was a really, really important aspect to those rules, and therefore those cases don't read on that case. I admire his attempt here to make that distinguishment. It is a viable line of argument given the line of cases and the way they're written. I just ultimately think it's wrong. I think Kagan had the better summary of it. I think ultimately the mandatory nature of the sentences was not material to the cases. And so I don't think those cases turn on that. It just happened to be true in those cases. So I think all that language can be safely ignored. I mean, he's not wrong to make this line of argument. I just don't think it's going to win the day. And so I think he loses on both lines of argument. He loses on the fact that Even if he's right that's procedural, not substance, it doesn't matter because the substance didn't exist then either, so the procedure didn't exist. And he's just wrong, I think, on the interpretation of the case law, that even though it says mandatory like 8,000 times, it ultimately is immaterial to the case. It has to do with juvenile. The baseline of the case is, as Kagan put it, that youth matters. That's the real holding of the cases. And so I think it's not a winning argument. He's making it very well. It's just not a winning argument.
Keep going.
The other thing I would say about the particular paragraph on which we're focusing here is I think it makes more sense if you view Montgomery as really being focused on mandatory sentences, which is all anyone was thinking about in the case. And I think what Montgomery is trying to do in that paragraph is to fit Miller's holding, which again Montgomery recognizes in several places is limited to mandatory sentences, into the language that this court has used to describe substantive rules. And it does so in a kind of unique way. It describes the boundaries of the class of defendants who are benefited under Miller using the procedural language of what a sentencer who sentences under a discretionary scheme would necessarily need to find. The terms transient immaturity and irreparable corruption come from earlier cases like Roper and like Graham, where they're used descriptively, not prescriptively, to describe the kind of judgment a sentencer necessarily makes in imposing this kind of sentence on a juvenile.
But if it is,
That's just to say you wish Montgomery was a different opinion. It's not a different opinion. It creates the test that it creates based on the language in Miller, which, you're right, was based on the language in Roper. So there's a chain of decisions, but there's a clear rule that comes out of it, which is this distinction between the irretrievably corrupt and all others.
Well, Your Honor, I don't think it's a especially clear rule, in part because it kind of, if I may use the word, fudges a little bit the way this Court's described substantive rules by describing it in procedural terms. Usually you describe a class by reference to some objective fact, like what crime the defendant...
The objective fact is the incorrigible.
So, Your Honor, I think...
that's not necessarily objective, but that is the fact that distinguishes the...
Those are the people who you cannot sentence in a certain kind of way.
Well, Your Honor, I think, and Justice Kavanaugh was just getting at this, it's not really an objective fact. It's a judgment that someone's going to have to make.
But that's the category. I'm done.
You can...
I guess I just finished with the thought that Montgomery's framing of this,
So his light
I don't
went
think
on.
is
That's why he said, "I'm done."
problematic if
The
it's
light went
limited
on.
to the only context anyone was considering in that case, mandatory sentences. But it becomes very problematic if the language is extended to invalidate all life without parole sentences under discretionary schemes.
Mr. Fagan, I would like to ask you about the government's change in position, because as I understood it, the government originally argued that juveniles sentenced to life without parole must be resentenced after Miller and Montgomery, whether life without parole is mandatory or imposed as a matter of discretion. That was the position that the government took, and most of the lower courts are in accord with it.
This is really neither here nor there. I just take note that Justice Ginsburg has completely ignored the light, but that's okay. I guess that's what happens when you're a member of the Supreme Court. The red light's going on. We don't care. We'll just keep asking questions. It's like, yeah, I guess you get to do that when you're a Supreme Court justice. I just take note. That's kind of funny.
What led to the SG's change in position?
Well, a couple things, Your Honor. First of all, as our brief notes, that wasn't invariably our position. That was our position in the Mejia-Velez brief that Malvo cites. But in other briefs, we took a position that is more consistent with the one we are taking here. And to the extent that we have changed our position here, it's because it's very difficult, as I've acknowledged, to reconcile the language of Montgomery and Miller, and it's not something that we lightly ask lower courts to do as a matter of clarification. We try to follow the letter of this Court's decisions. I think this Court has, frankly, somewhat more leeway to kind of explain what it had in mind in Montgomery, which I think were only the discretionary sentences, mandatory sentences that were actually at issue in that case.
Thank you, counsel.
So John Roberts finally closes him off because his gun well past the red light going on. That's okay. He was within the bounds of the rules, right? He finished the question and then, he answered as fast as he could, and then even though his light was off, she answered a question. And so he gave a quick answer, and he's like, okay, we're done. To answer St. Dinger's question, there is amount of time per side, and that time is per the justices and the advocate to share. And the judges get as much of that time as they want. So hypothetically, you get 30 minutes. In reality, you get as much time as there are not questions being asked. So, if they eat all your time by asking questions, then sucks to be you. There are no time limits for the judges. They get to ask as many questions as they want. And with 9 of them, sometimes the amount of time you get for argument is decidedly less than the 30 minutes that you were promised. But, oh well, tough cookies, as they say. That's just how it goes. That's, you get as much time as they let you have when you're there. It's like, I have a half hour. It's like, and then you look where it's like, I had 4 minutes. Oh well, that's how it goes.
Ms. Spinelli?
Mr. Chief Justice, and may it please the court, Miller and Montgomery control this case. The warden and the United States have just conceded that in order to rule for them, this court would have to discard the reasoning of Montgomery. Miller held that before imposing life without parole on a juvenile, a sentencer must consider how the characteristics of youth counsel against that sentence. That individualized...
So Evan Marshall says we're wasting time on this. Well, we're probably wasting time on Malvo, because like the absolute best case scenario for him is that they send him back and they still say and they still find that he's not incorrigible or irredeemable or whatever the exact language is. But even in the best case scenario, he gets sentenced to 8 sentences of life with a possibility of parole served consecutively. So it doesn't really matter very much for Malvo in the end, because the best case scenario for him is he serves the rest of his life in prison. But of course, cases are not always about the case in front of us. The case is about all the cases. And so there are a lot of people who might be impacted by this one way or another that are not Malvo. Now, why they chose to take Malvo of all the possible cases as a vehicle to do this is questionable. So when we talk about a vehicle, what we mean is we're looking for a case that cleanly sets forward a proposition. It's a good avenue to address the question, and they call it a vehicle. So why is this the good vehicle to bring this case? I don't know. Doesn't seem like the best vehicle, but the Supreme Court chose to pick it, so I don't know. But it's the one we have. So yeah, it won't matter very much for Malvo in the end, no matter what happens. But it'll matter to other people. So okay, carrying on.
Sentencing hearing, as Montgomery explained, effectuates the 8th Amendment rule that life without parole is an excessive sentence for most juveniles, those who are not permanently incorrigible. Miller is not limited to mandatory schemes where life without parole is the only possible punishment. It invalidated those schemes because they guarantee that courts won't consider whether youth warrants a lower sentence, which creates an unacceptable risk of excessive punishment. But when a court has the theoretical power to consider a lower sentence but doesn't do so, which is what happened here, it creates precisely the same risk, as the warden admits in his reply brief. And I'd like to correct some of the statements about what actually happened at the sentencing hearing here, because this is important. Malvo was sentenced in 2004. That was not only before Miller, it was before Roper. The prosecutor sought a death sentence for him. The issue before the jury was, should he be sentenced to death or life without parole?
So that is an important distinction that I was not quite keeping in mind, because Roper is the case that said you can't convict juveniles to the death penalty. So this case happened at a time when the death penalty for a juvenile was still an option. So they were asked to consider the death penalty and they didn't give it to him. So in that sense, I suppose life without imprisonment was not a mandatory sentence because death penalty was possible. So it was the lesser penalty. So, okay. That's interesting because Roper didn't exist yet. Okay. I'm not sure if it matters very much, but interesting little factoid.
It was the only issue they were allowed to decide. At the sentencing hearing before the judge, which is extremely short. It's 8 pages at the end of the joint appendix. There was no consideration at all of imposing a sentence less than life without parole. And until a footnote in his reply brief, the warden hadn't contested that. It's pretty hard to contest. The notion that, somehow Miller was satisfied by, the opportunity, the theoretical opportunity to consider youth when it wasn't actually considered simply can't be squared with the language of Miller itself or the language and reasoning of Montgomery.
That argument you're making is about the Virginia scheme, and get to that, I think. But there's an initial question about what Miller and Montgomery mean. And you heard my question about the substantive rule being something that separates the incorrigible from the merely immature. And the procedural rule, particularly articulated in Montgomery, is you don't need to make a finding of fact. A discretionary regime satisfies it. And my question to you is, why isn't a discretionary regime, and I know you disagree that Virginia is such a thing, but we'll put that aside for the moment, why isn't a discretionary sentencing regime enough procedurally to satisfy the substantive rule articulated in Miller and Montgomery?
Because the substantive rule, which I think I agree with your articulation. The substantive rule requires that in order to ensure that juveniles don't receive an unconstitutionally disproportionate punishment, a court must consider the characteristics of youth and must make a determination as to whether that juvenile.
Okay, so I'm sorry to interrupt, but this is important. You said two things there: must consider, and you said must make a determination. Both opinions definitely say consider over and over again. Consider or take into account are the words used over and over. Assess, used a few times. It never says make a determination. Neither opinion ever, I think, says make a finding of fact.
It does not say make a finding of fact. I agree with that.
Okay, and then the question becomes, if a discretionary regime suffices to allow consideration, isn't a discretionary regime sufficient to satisfy Miller and Montgomery?
No, it's not. In this case, actually, let's just stick to the broader question.
Yeah.
Miller makes very clear that sentencers must actually consider the characteristics of youth and determine whether life without parole is a proportional sentence for the individual defendant.
I'm going to stop you again. I'm sorry, but in most sentencing regimes, as you well know, throughout the country, in the variety of sentencing courts, judges are required to consider all sorts of factors by state law. And arguments are raised to the state court judge, the trial judge, about all sorts of factors. The judge will often impose sentence without marching through a checklist of all those factors. Yet it is routinely accepted that the judge has, quote, considered the factor if it has been raised or even if it's required as a matter of state law. There are lots of state cases and federal cases that say so long as the issue's been raised, we assume the judge, quote, considered it. Now, if that's true, and you can disagree with that, but if that's true, doesn't a discretionary regime where the argument can be raised necessarily satisfy Miller and Montgomery's requirement of consideration?
All right, so that's a really, really good question by Kavanaugh. So he's saying, look, there are a lot of situations in which by law, by state law, by federal law, by a lot of operations where courts are asked to explicitly consider a whole bunch of things, except certain things in aggravation, except certain things in mitigation, they must consider a whole bunch of factors. But he's saying that routinely in courts around the country, the judges don't do this explicitly. They don't, like, in their opinions, or they don't do some sort of check law list where they say, like, they considered it and, like, did you consider this factor, and, like, explain how, and, like, write, like, sentences. They don't do it in some sort of explicit way a lot of times. And he's saying, according to the case law that exists, we say that a judge considered it as long as someone raised it at some point. The judge doesn't have to mention it. The judge doesn't have to list it in his opinion. As long as someone raised it at some point, the judge has considered it, even if he didn't mention it. And so isn't this in this same exact category where this is a thing that the judge considered, and therefore the whole issue is moot? The judge actually, because according to the case law, the trial court can sentence the juvenile to life as long as he's in this incorrigible irredeemable status, but you have to consider youth. So the question is, because youth is a factor, can't we just say the judge did that and therefore he did meet the substantive requirement after all? It's actually a really, really sharp question from Kavanaugh. So let's listen to her answer.
No, it doesn't. And let me explain why in this particular case it doesn't. Because this was decided he was sentenced not only before Miller, but before Roper. There's no possible way that the judge could have, silently in her head considered the factors that weren't even articulated in the first instance by this court until much later.
So I think that's a very, very fair answer in response. It's like, look, this happened before Miller, happened before Roper. So how could the court possibly have considered things that didn't exist at the time? So I think that's a really sharp answer. Lint asks, so I've noticed Kavanaugh seems to be quite active here. Are there justices letting him dig in to get his footing on the bench? I don't think it's that overt. And I've heard a lot of justices, when they're new, not be particularly active. And he wasn't particularly active in the cases dealing with the transsexual gay rights, as I remember. He wasn't particularly active in those cases either. So, yeah, he's being a little bit more active here than other justices. But Kagan's been very active. Sotomayor's been very active. Ginsburg had her moment. Roberts had a little moment. I don't think he's being unduly dominant, but he's being pretty active. I don't think it's that explicit, though. He's probably feeling out his role in terms of like questions asked and stuff like that. That's probably true.
I may or may not agree with that. Assume going forward, a sentencing judge, though, in a discretionary sentencing regime is presented with arguments that you should not sentence this juvenile to life without parole because of his or her youth, and then explains that. The judge then sentences the juvenile to life without parole. In that circumstance, has the judge considered the youth?
It's possible that that could be sufficient under Miller. One would have to make a determination, looking at the record, whether there was some judgment made that life without parole was, in fact, the proportionate sentence for that juvenile.
There is a line in Miller that says, and this is the one they hang their hat on, that Miller did not impose a formal fact-finding requirement. That Miller did not impose, this is from Montgomery.
Yes.
That Miller did not impose a formal fact-finding requirement does not leave states free to sentence a child whose crimes reflect transient immaturity to life without parole. So there's a substantive right.
Precisely, Your Honor.
If your crime was of transient immaturity, not to be sentenced. Now, presumably, what I think my colleague, and he can correct me if I'm wrong, is saying, in a discretionary sentencing, moving forward after Jones, courts know that they have to take age and youth into account.
Correct.
So it's like now, 3553 of the Federal Criminal Code requires a laundry list of things for judges to consider. Most judges do not tick off each one of those. Doesn't say, I find this, but I don't find that. I don't do this, I don't do that. Most judges just say, I've thought of them all, and this is my answer. Now I think what Justice Kavanaugh, he's shaking his head yes is, in that kind of system, assuming that this was a post-Jones case, not a pre-Jones case, for which there's some ambiguity, why isn't that system enough? Are you requiring a formal fact-finding? Are you saying as long as it's clear that the judge knew that he had to find incorrigibility and that was argued before him and he didn't have to say I find it, but he sentenced the person to parole, that you assume he knows what he's doing? That in the absence of those arguments, that then you're not sure and the substantive right should trump? I'm not sure how.
So if we were dealing with a situation in which there was a statute that mirrored the requirements that Miller set out, it would be a completely different case. That is not what we have here. This judge was not required to consider youth.
But a lot of the state statutes, and this is what I think is concerning some of my colleagues, have since Miller said it's discretionary now.
Yes,
Courts don't have to do mandatory life, and they should consider age. Now,
that's correct.
I must admit that I read Jones, but I don't remember if Jones said age must be considered in light of Miller.
It did not say
or
that.
in light of Montgomery's substantive rule.
It did not say that.
All right, but that's the assumption being made.
Yes, and
what are you asking for? All of those other systems post Jones that let or tell judges to consider age, but don't say in accordance with Miller and Montgomery. Don't we presume that they know the law and follow it? That
going
those judges
forward, yes, I agree. If a judge sentences a juvenile under one of the post-Montgomery statutes that sets out the factors that are articulated in Miller and Montgomery, then yes, I think it might be reasonable.
It sets those out and requires courts to evaluate them?
Precisely, yes.
As opposed
yes,
to, for example, either that doesn't set them out or that just, permits courts to do whatever they want.
Yes.
Right?
And
there are different kinds of non-mandatory schemes.
I apologize.
Well, no, I don't know which
no,
one
please,
I was
Mr. Chief
interrupting.
Justice.
Sets them out like in 3553. Is that the sentencing considerations?
Well,
is that enough? Here are the things you need to consider, and transient youth or incorrigibility is one of them.
If there is a statute that expressly sets out these factors, and if the judge considers them
and requires the court to consider them.
And requires the courts to consider them, then we can presume that the judge followed the law and did so. But this is not a case where the judge was required to consider anything. And, in fact, she did not consider imposing any lesser sentence than life without parole. And the warden's position and the United States' position is that that's good enough.
Back on Justice Kagan's question for a second.
So the question was asked from Lynn. Is Spinelli arguing pre-post argument? They're asking hypotheticals about what would happen in a post universe, and so in a post universe where a judge has to consider these things, he doesn't have to make it explicit. He doesn't have to make official findings. He just presume that he knows it. So it's how do you know what the judge was or was not considering at the time is the operative questions. In a post world where a judge doesn't have to make findings, then in a pre-world, we don't know what the judge was considering either because they don't make findings now. So that's kind of what's going on. Cody Sam says, I see a lot of lawyers pleading their case tend to talk fast. Is that nerves or being on the clock? Man, I don't know if it's as bad as it used to be. Sometimes when I listen back to myself, I still think I talk pretty fast. I used to talk quite a lot faster. Part of it is from being on the clock. Part of it is from when back in speech and debate days where we used to do speaking a lot faster. And part of it's I feel like I have so much information that I want to share. It's just feels like, so it's a combination of things. Nerves are definitely a factor. I can attest to that much. That's for sure. And I've never had the pleasure of arguing before the Supreme Court, but if I wasn't a pile of goo, I think I'd be doing pretty well.
In a discretionary regime where the sentencer is required to consider certain factors, or even if not, it's just a discretionary regime. The defense counsel, in any case where juveniles facing life without parole is a possibility, is of course, I would think, you would agree, any competent defense counsel is going to argue the youth to the sentencing judge. Do you agree with that?
Going forward, yes.
Yes. Okay. And therefore, can't you presume, and don't we do this as Justice Sotomayor was indicating, I'm not putting words in her mouth, but in 3553A cases, we also presume when something's been argued to the sentencing judge that the judge has, quote, considered, unquote, that factor.
Yes, and let me be clear. I don't think this court needs to say anything about how to handle cases going forward after Miller where there is a requirement that the judge consider the Miller factors. The question here is, does Miller apply? Can Malvo invoke?
Well, I think we have to say what Miller and well, I don't know what we have to do, but we might want to say what Miller and Montgomery mean as a rule together, because that's been a lot of the focus of the brief. So we may have to indicate what is the substantive rule and what is the procedure, and then we can figure out.
Yes. Well, the substantive rule is that the Eighth Amendment forbids states to impose life without parole on juveniles who are not permanently incorrigible.
And that's the holding of that is the holding of Miller.
That is what Montgomery.
Well, could Montgomery change Miller? In Montgomery, the issue was whether Miller was whether the rule adopted in Miller was retroactive to cases on collateral. Doesn't it have to take Miller as it stands? Can it change that?
It shouldn't, and it didn't. What Miller,
okay, if it didn't, then we can disregard whatever Montgomery said and look at what Miller said. Where does Miller say what you say that it says?
It says
It says
on
exactly what it held. It says, we therefore hold that the Eighth Amendment forbids a sentencing scheme that mandates life imprisonment without possibility of parole for juvenile offenders. That was the holding.
That was the result. There is also the reasoning that was necessary to that result.
That wasn't the holding? When they said we hold, that wasn't?
It was certainly part of the holding, but the court also said we require a sentencer to take into account how children are different, and the reason that it requires that is in order to effectuate the Eighth Amendment prohibition on disproportionate sentences for juveniles.
Counsel, if there were a requirement of a substantive right to a finding of incorrigibility before the sentence of life without parole were permissible under the Eighth Amendment, wouldn't it follow also that there's a Sixth Amendment right under Apprendi to have a jury decide that rather than a judge?
Good, very, very good question from Justice Gorsuch there, asking if there is a requirement of finding of incorrigibility, doesn't that require a jury to decide it? Because the general case law, this didn't used to always be true, but the general case law now is if there is a fact that has to be established in order to be a sentencing enhancement, it has to be found by a jury as part of their jury deliberations. And so he's saying, look, if there is this finding of incorrigibility, if that's a finding, isn't it a finding that requires a jury to decide? It's an outstanding question. I would think that the answer probably is yes under the current case law, but she's about to say no, but we'll see, because yeah, if it's a fact that has to be found in order to be a sentencing enhancement, it has to be found by a jury. And now they do these explicitly. It didn't used to be that way, and now it is that way. So very good question from him. I like that question a lot.
I don't think that necessarily would follow.
How?
I think that
anytime we increase the sentence, statutory maximum or otherwise, sentence, we say jury. This court has said a jury has to make that finding.
There's actually a split of authority. There's no indication
of any of that in Montgomery or Miller, is there?
Agreed. There's a split of authority on this question. There's a pending cert petition that raises it. We don't have any position on it.
Well, the court has held several times if you increase the statutory permissible range of penalty, a jury has to be involved, right? I mean, that's not.
Yes, so it depends
there's no circuit split on that.
It depends on how you conceptualize it, but that's clearly not one of the issues that's before the court in this case. And I'm not arguing, just to be clear, that there is a requirement of a specific factual finding. Montgomery said there wasn't, but what it also said is there has to be a hearing that separates juveniles who make constitutional.
And a hearing, if the substantive right is that you cannot do life without parole for an incorrigible youth, there has to be a hearing, and somebody has to make a finding about that. It's not just a matter of discretion anymore. It's a matter of a factual finding.
Gorsuch is 100% right here on the law.
It's a finding. And I would have thought in those circumstances we might have specified who would do that finding and how that hearing would be conducted consistent with the Constitution.
Well, that issue was not resolved in Miller or Montgomery, and I don't think it needs to be resolved today.
Isn't that a further strike, though, against your interpretation of Miller and Montgomery, that the court would have created a new substantive right that implicates the Sixth Amendment and not ever said so, or even hinted at it?
That's a really good point from Neil, actually going to the issue of the prior case law, saying, look, it can't be the case that you create this new substantive right, because if you had, it would have to be a trial by jury, which implicates the Sixth Amendment, and the court never discussed it. So it can't be the correct reading. It's a very, very sharp reading of that, and goes to show Neil Gorsuch is much smarter than I am, because that is really intelligent. I mean, it's just like the chain of logic to get you to that point is like, I can follow it now that you've got me there, but I don't think I can do that on my own. I can't, I think Neil Gorsuch is just smarter than me. So the fact that he did that humbled me a little bit, to be quite honest, because it's like, it's a very sharp line of reasoning.
Or even acknowledge the question.
I actually don't think that's unusual. It happens, it happened with some regularity that a new rule will be announced, and then later the issue of, who makes this decision, a jury or a judge, will come up. That's what happened in Atkins.
This is a pretty big issue, though, right? I mean, the judge or the jury, if we're creating a new substantive right, we might want to say a few words about, hey, there's an issue whether the judge should do it or the jury should do it, and we'll take that up in the next case.
That is what happened with Atkins. Atkins is very similar to this case in that it barred the imposition of the death penalty on the intellectually disabled. As in this case, there needs to be a procedure to sort out the intellectually disabled from those who are not. And the question arose after Atkins, does that determination have to be made by a judge or a jury under Apprendi? And the majority of courts, that I know of, the majority have said, no, it doesn't have to be made by a jury. It can be made by a judge, and states have allocated that determination in different ways. So it's not at all unusual that the court wouldn't have addressed the Apprendi issue in these decisions. But, to return to Justice Kavanaugh's question about procedure and substance, the two necessarily go together. The necessary procedure has to effectuate the substantive rule, and therefore, as Montgomery says, it has to involve a determination as to whether life without parole will be a proportionate sentence for that particular defendant.
We know it doesn't require a formal finding, right?
That is correct. It doesn't require any particular form of words. It does require a substantive result.
Well, you said it requires a determination, and to me that sounds like a formal finding. And the one thing we do know is that a formal finding is not required. So it would seem that consideration, and I thought we had gotten that far before, sort of it being included with respect to factors that must be considered in imposing a sentence. We were talking about 3553, which has a list of things that have to be considered, and this would be one of them.
Yes, and again, we're not presented here with the question of what exactly a fact finder would have to say.
Well, you are, because I asked it.
I'm sorry, Your Honor. I apologize, Mr. Chief Justice. What I meant is, that is going to be an issue no matter how the court decides this case. There have already been 2,000 resentencings under Miller at which courts have made an effort to apply the Miller factors. Montgomery did not specify a turn of phrase or a specific finding that has to be made, but what's absolutely clear is that the court does have to decide whether, in light of the characteristics of youth, this is a proportionate, life without parole is a proportionate sentence for this particular defendant.
I'm half tempted to make this a lot easier and ignore really the issues that are being raised and to go under another doctrine which basically says harmless error. Basically, regardless of what the answer should or could be, it really makes no difference, because in this particular case, you're dealing with a juvenile who committed multiple murderers. He's a serial murderer by the time he's 17. So, what difference does it make? Had they done everything you were asking for, it would have made no difference. So I'm half tempted to make this a lot easier and just say harmless error. Who cares what the answer is? It doesn't matter. So that, like, made this way easier. So yeah, it's like, yeah. But as I pointed out, it's not just about him, which also is like why they take this case. Again, going to the vehicle questions, like there's a valid issue to be had here, probably. Not really a valid issue as it applies to Malvo. I'm not sure this was a good case for the Supreme Court to raise this issue, because it's like, as it applies to Malvo, who cares? Who cares? No one cares. He falls into the irredeemable category. Serial murderer, Vans, sniper, DC. Yeah, it doesn't matter in the end. So, not a great vehicle for this case. So I don't really know why they took cert. But okay, carrying on.
And that
I don't think Montgomery says decide. I mean, decide to pick up on the Chief Justice's question sounds like determination, sounds like finding. Maybe I'm.
Well, what it
key
says.
Paragraph it says.
What it says is. A hearing where youth and its attendant characteristics are considered as sentencing factors is necessary to separate those juveniles who may be sentenced to life without parole from those who may not. Mm-hmm. It then goes on to say, no, we didn't require a specific finding of fact. We are leaving it to the states to...
It doesn't even say specific. It just says finding of fact.
Correct. It just says finding of fact. But it then says that Miller did not impose a formal fact-finding requirement, doesn't leave states free to sentence a child whose crime reflects transient immaturity to life without parole. So Montgomery doesn't provide a lot of guidance, but what we do know is that juveniles are entitled to at least one opportunity to show that they are not permanently incorrigible, and that it is not right to make a determination now that they are foreclosed from ever attempting to show that they have changed.
And your argument that Virginia did not provide that is?
It absolutely did not provide that. There was no. So let's assume that Jones was correct and that there was an ability to request suspension. That was not even remotely clear at the time.
Let's say it was.
Mulligan's about right. Yeah, Mulligan's. Yeah, it's like, who cares?
If it was clear that he could request suspension, I still don't think it would matter, because a suspension hearing is not a Miller hearing. At the time, Roper hadn't even been decided.
I understand that, but let's just say hypothetically that it was available to the defendant to argue whatever he wanted with respect to his youth and attendant characteristics in any fashion that he wanted, and that the judge had to consider whatever arguments were presented about youth before imposing a life sentence, and that the judge could not impose that life sentence automatically. And let's say that's the state of the law in Virginia, hypothetically. Now, maybe we don't know that, but let's just assume that all arguments are available, not just incorrigibly, any arguments about youth are available. Even better for the defendant. All of it has to be considered.
The hearing that Miller requires, however, is not only a hearing that requires that youth be considered. Youth is considered in all kinds of contexts, but Miller's specific holding is that the characteristics of youth that were identified first in Roper need to be considered in order to determine whether or not life without parole is a proportionate sentence.
I'm positing a hearing, counsel, in which all of that is available to the defendant to argue. Then what?
I mean, it was available to him to argue in the sense that, every new rule is available to the defendant to argue before the rule is announced. In fact, he had no way of anticipating that this new constitutional rule would be announced. The court hadn't even taken the first step down the road toward that. So, even if it were the case that he absolutely could have gotten the same consideration had he, been able to look into the future, that is not what we typically require defendants to do, and that's why the Miller rule is retroactive in the first place.
We're in an awkward place because of what the Virginia court did with Jones, which is sort of look at something retroactively and say, this is what you could have done there's a lack of clarity whether judges understood they could have done that.
But
let's move forward after Jones, okay? And Jones is after Miller and Montgomery, correct? So it's now they're saying judges can have complete discretion, just the way that Justice Gorsuch has posited. Moving forward, they should consider age and all its attendant circumstances. Why would that system, moving forward, I'm not looking backwards, if someone is sentenced today and their attorney failed at the hearing to argue incorrigibility, or the lawyer argued it and the judge didn't say one way or another, what I posited it earlier, he just said, I've considered all the factors they told me to consider in Jones, X sentence.
Well, first, Jones did not say that courts had to consider age in light of Miller, or that they had to consider age at all. What it held is Miller is completely inapplicable in Virginia because we have a, quote, discretionary system.
I have to read Jones more carefully.
Going forward, however, and going forward, Virginia is not doing anything to comply with Miller. So let's be clear. When Miller was issued, there were about 2,800 juvenile lifers in, quote, mandatory and non-mandatory schemes. Almost every state has already resolved this issue and complied with Miller and understood it the way we understand it. There are only 60 states which only have 60 juvenile lifers that haven't either made them parole eligible or begun resentencing them in response to Miller.
Did I mishear you? Did you say 60 states or 6 states?
6 states with 60 juvenile lifers.
Thanks, Sotomayor, for the mercy correction. She definitely said 60 states. So, yeah. Well, thanks for the mercy correction. Yeah. Like what Obama said, what was it, that I traveled to all 57 states? Yeah. Never mind. Carry on.
Out of 2,800. That is the scope of the problem that we're dealing with.
But if you could answer Justice Sotomayor's hypothetical, that would be very helpful to me as well. Let us assume that all arguments are available at the hearing, and the defendant makes some, not others.
I am not arguing that this right cannot be waived. Going forward, this is a known right. It can be waived just like any other constitutional right.
Counsel, if I might. So just all arguments are available, and the district judge has to consider them. Would that, in your mind, satisfy Miller and Montgomery?
It might very well.
Ewan Marshall says, easy to trip up on words this fast. Man, don't mistake that I'm like making undue fun of this woman, because I'm impressed she knows the case names. I'd be like, I just to be able to keep the case name straight in your head and be like, oh, is this case not this case? Like, because one attorney earlier messed up a case name, he corrected himself. But like the amount of stuff they have to keep in their head and keep straight, it's like, yeah. So of course you're gonna slip every once in a while. So I'm not making fun. It's just like, just making note that she gave a mercy correction. And I've like had streams with Leonard when I've been listening back to them, and I was like, oh, I didn't hear it the same way that I heard it when I was there. You know, I remember one time listening to a stream where I corrected Leonard, even though Leonard said it correctly, and I was like, and he's like, yeah, that's what I just said, because I had misheard it. And then listening back to the audio, he had said it right the first time. I was like, oh, so, hey, you know, what can you do? It's a lot to keep in your head, I guess.
Okay.
Yeah, I am not arguing that it would not.
She does seem a little on the anxious side. She does seem like a little bit that she's a little anxious prone. But that being said, I think she's very professional. She's doing a very good job. She's speaking a little fast. I speak a little fast. And so she's a little bit, you know, could have used maybe a Valium or something, not to be disrespectful. But look, I mean, it's a nerve-wracking environment. I think she's doing a very good job. She knows her material. She's sharp. She's doing an excellent job. I'd be thrilled to have her represent me. I'd be lucky to have her represent me. I think she's doing an excellent job. So, in fact, I think on the whole, the women seem to be doing better than the men, at least in the cases we've heard so far. So, you know, notable. Or maybe it's not notable. It's just something to... They've been doing a really good job. Although it didn't help that one guy, Cole, was so horribly disastrous that, I lost the will to live at points during his argument, during the transgender debate. He was so bad. I was like, why am I still alive? Why are there still things that exist? That was pretty bad. So that didn't help the curve.
We're only talking about the situation here where there was no consideration of youth, not only with Malvo, but all 13 of the people who are serving juvenile life without parole for capital murder in Virginia were sentenced in exactly the same way. In none of those cases was there any meaningful consideration of a lower sentence, let alone consideration of whether youth made life without parole unconstitutional. In the only 2 cases where defense counsel raised the possibility of a lower sentence, the prosecutor said, absolutely not. Life without parole is the mandatory minimum sentence. So we know that, and the Fourth Circuit made a finding, and the district court made a finding to this effect, that youth was not considered in the way Miller requires. And
in what way was it necessary for the youth of your client to be considered? Do you think you describe him as a child who committed these crimes because of transient immaturity?
I have not described him as a child who committed these crimes because of transient immaturity.
Well, I thought that was the test that you're saying that the court has to apply. Whether it is a child who committed the crimes because of transient immaturity.
The question is whether the juvenile committed the crimes based on transient immaturity or permanent incorrigibility. And what we are asking for is a hearing in Virginia court where the Virginia sentencer will make that determination. He has not had that hearing yet, the hearing that Miller and Montgomery require, and he is entitled to have one opportunity to make the case that he is not permanently incorrigible.
Is not now or was not at the time?
Well, I think by hypothesis, this is, if one is permanently incorrigible.
Yeah, Evil Coleslaw, I'm with you. You say, transient immaturity doesn't seem to be an excuse for multiple indiscriminate murders. I have to concur with you. I like to think that I'm a guy who applies both justice and mercy, and I'm a guy who can appreciate that people who are young sometimes do stupid things, but there's stupid things, and then there's committing multiple murders from a van using a sniper rifle over a several-week period in the greater D.C. area. That's I wouldn't describe that as immaturity. That's not, I drank too many beers and I accidentally hit a mailbox with my car. That is planning methodical serial murder. So, good,
That's a permanent quality. So it certainly is relevant on resentencing what someone has done since they committed the crime. They may well have, been able to provide evidence based on what they did after the crime that they are not, in fact, permanently incorrigible.
So if he can demonstrate as a result of good behavior in prison, for example, that he has been rehabilitated, then he must be released?
No, absolutely not. That's one piece of evidence that the sentencer can consider. The sentencer then can decide what is the sentence going to be. On resentencing, there are occasions when juvenile offenders are resentenced to life without parole. Even if he were given parole eligibility, that would not mean that he would be released. It would mean that he would have the opportunity sometime in the future to make the case to a parole board that he has changed. So we are nowhere near any prospect of being released. So, the warden and the United States have made it extremely clear that they are asking this court to discard the reasoning of Montgomery, and there's absolutely no reason for the court to do that. All of the arguments that they've raised were also raised in Montgomery, and the court declined to adopt them, and it shouldn't change here.
Thank you, counsel. General Heitens, 3 minutes.
Juan asked, what was the type of hearing or hearing a similar situation in MD courts? He has first 4 sentences in Maryland. I don't know the answer to your question. I don't know what resentencing, if any, he's had in Maryland, and it wouldn't be material to this issue, strictly speaking, because regardless of what Maryland did, even if they've done this, Virginia may still have to do resentencing. I mean, the whole thing is absurd, right? Because, like, if Maryland's already done the process, and he's facing 4 life sentences over there, it's like Virginia, I mean, like, he's never getting out of jail ever. Nor should he, in my humble opinion. Again, I'd like to think that I'm able to be compassionate, but there's, boys will be boys, and then there is shooting people from the back of a van for several weeks in the greater DC area and murdering multiple people. So there's like, my levels of compassion do not extend this far. There's immaturity, and then there's evil, and Judge Blackleaf's resentencing decision would be pretty short. It's like, yeah, I considered it. No. So I don't know what difference it would make, but it's like, you really want to come to Judge Blackleaf so I could sign a piece of paper, be like, yeah, I considered it. No, that would I'd be doing that. That's fine. But the law is the law, right? And so whether it makes any practical difference or not, the law should be followed. So I'm happy to consider it. Just, once again, multiple murders from the back of a van in the greater DC area for a couple weeks. Yeah, that's a lot of thing to overcome there.
So I'd just like to address 3 points: what Miller requires, the shifting nature of Malvo's arguments, and why this matters. So I think Miller is quite clear what it requires, because it's in the very last paragraph of Miller. The court says on page 489, the judge or jury must have the opportunity to consider mitigating evidence. And Mr. Chief Justice, you asked, how do I know he had that opportunity? I can report Virginia Code 19.2 264.4, which is in the red appendix at 3, says he had that opportunity. And the Virginia Supreme Court's decision in Jones says it.
All right, so just when he says the red appendix, he literally means the color red, because I can't tell you off the top of my head, but every brief has different colors. So, like, the petitioner's brief has a color, the reply brief has a different color, the response brief has a different color, amici briefs have different colors. They literally have different physical colors to help distinguish them. So the red appendix is literally the color red. It's notable. It's one of the things that makes printing for the U.S. Supreme Court a pain in the ass. Also, the fact that it has to be on the special size paper no one else uses. It's like 6 1/4 by, what is it even? I have to relook up the rule. It's like 6 1/4 by like 5 1/8 or some bizarro paper no one would ever use. And that's why it costs $10,000 to submit a brief to the Supreme Court. Because, no one has this paper. You can't go to Office Depot and buy this paper. No one makes it. Supreme Court going to Supreme Court, I guess. Can it be on 8.5 by 11 or A4 like everyone else uses? No, that'd be way too much. It has to be on this 6 1/4 by 5 3/8 paper. Never mind.
At 795 SE 2nd at 722. They specifically say, quote, nor are we aware of any case in which a sentencing statute gave the juvenile offender the opportunity to present mitigating evidence, but the sentencing court arbitrarily refused to consider it. If there were such a case, we would not need the Eighth Amendment, because that would be reversed as a matter of...
And how about the case they cited where counsel did raise this argument about the youth, and the judge said, I have no power?
I think that would be, first of all, that's not this case, because there was no such objection.
But it does provide some evidence that plus the history that before Jones there was no juvenile convicted of life without parole whose sentence was ever suspended.
But I think at most under Jones that establishes that individual was sentenced in violation of state law, not in violation of the Eighth Amendment, and that's not Mr. Malvo. Mr. Malvo never requested such an opportunity, and had he requested such an opportunity, he could have pursued if he requested that opportunity and the trial court refused to do it, he could then have appealed to the very same court that decided Jones too and said the language that I just quoted.
The practical reading that I would give of these cases possibly. first case, you cannot sentence under a state law that's mandatory a juvenile to life without parole. Why not? Because nobody's really considered whether he's immature. So it's the reasoning. It's not this procedural. That's the reasoning. This case, they sentence him to life without parole, and the odds are greater than 50-50 that no one ever thought about whether he was, in fact, immature. Okay? That sounds to me like the same case. Now, leaving all these words out of it, why isn't it the same case? I mean, I know words like opportunity, da-da-da-da-da, but isn't there enough to say the odds are better than 50-50?
Well, Justice
no one ever thought about that.
Well, Justice Breyer, I won't say opportunity then. I will say Teague.
No, you can say anything you want. I'm just trying to
But
get
you
away
have an opportunity
Thank you.
your rebuttal to say it.
So I think under Teague, it's clear as day that for Mr. Malvo to get retroactive relief, he needs a new rule. The only new rule he sought habeas based on was Miller, and most of his discussion today was about Montgomery. The court should reverse. Thank you.
Thank you, counsel. The case is submitted.
Well, okay, so that's the end of the case. Couple comments. See, either SCOTUS for making undue financial burden by requiring off-site swiper. Look, if you are indigent, the Supreme Court will find someone to pick up your costs, so don't worry about it. It does happen, and they will assign you a lawyer. And incidentally, they did change the rules explicitly. Like, it wasn't actually that long ago they changed it. I'm trying to remember, like 5 years ago, or it wasn't that long. They explicitly changed the rules that you cannot be pro se and argue before the U.S. Supreme Court anymore. I don't know when it actually happened last that someone cared about it, but they actually did change the rules. You cannot be pro se and argue before the U.S. Supreme Court. So if you're a pro se and you get to the U.S. Supreme Court, they will assign you a lawyer, and it will be a really, really good lawyer. It will be better than you could ever hope to do, and you should be very happy about it too, because the Chief Justice of the United States is going to give some lawyer a call and then say, would you like to do this case on behalf of this guy? And so not only are you trying to like work for your client, you're also trying to basically, the court just called you. They tapped you to do this. So like as much pressure as you might otherwise have, like the amount of pressure goes up, because like you don't want to embarrass the court because the court just asks you to handle this shit. It's like, yes. And like, it's not like you have to hunt to find lawyers that will do it for free, because it's such an exposure. It's like there's like 3 billion people that the justice could call. Hell, if he called me, I'd do it. You know, I'd happily do it for free. I'll pick up the cost myself. I'll print it out on my damn personal account just because it's so like the experience is so worth it. So yeah, so I wouldn't worry about it. If it comes up, you can apply for indigent, and someone will pick up the cost for you. So don't worry about it. Yeah. You should be very happy you got there as a pro se. I mean, hey, stranger things have happened. You know, Gideon versus Wainwright. The case that says that you have a right to a lawyer is Gideon versus Wainwright. That case was written by the prisoner on prison stationery and sent to the U.S. Supreme Court as a petition, and they granted the petition. So stranger things have happened. Because Gideon versus Wainwright, the guy was denied a lawyer because the case didn't exist yet. He was the case. So they denied him a lawyer at his trial, and he was convicted. And of course, he didn't have the right to a lawyer on appeal. So he wrote his own appeal on prison stationery and sent it into the U.S. Supreme Court, and they granted the appeal and then said that he had the right to a lawyer. So, you know, stranger things have happened in the history of the U.S. Supreme Court. So good times. Are all attorneys required to perform a certain number of pro bono hours? Not required to, but the rules of ethics in many states do strongly recommend it. But they're not going to disbar you for it. But yeah, they do strongly recommend it. So I wouldn't worry about it. So what do I think? Well, if they actually get to the merits of the case, I think Malvo wins. I think 7-2 probably. In dissent, I would say Kavanaugh, because Kavanaugh he's very state friendly. So I'd say Kavanaugh's in dissent. I'd say Thomas is in dissent. And that's about it. I think if they actually get to the merits of this thing, 7-2, and I don't know, pick your favorite justice to write the majority opinion on this. Breyer, maybe. Doesn't, whatever. It doesn't matter. So if they actually get to the merits of this thing, I think 7-2. I think Malvo wins. because the distinctions they're trying to slice are too thin. And the precedent does seem pretty clear, and it doesn't turn on the points they're trying to turn it on. Now, the odds of them actually getting to the merits, I think, are not exceptionally high. I think the odds that they could dismiss this as imprevidently granted and dig it is not zero because it's not a great vehicle. I think the possibility that they could remand this for the factual distinction, just so they don't have to decide the actual issue, is not zero, so that they, remand this for further factual findings is pretty high probability. But I don't know. I think on balance, I think probably they'll get to the merits. So if I had to guess, because I will guess they actually will get to the merits, and I'll guess it's going to be a 7-2 decision. I would guess, Justice Breyer will write it for the majority, and Justice, Kavanaugh will probably write a dissent, and Justice Thomas will join. That seems like something that would happen. So, what's the strangest thing that's happened in the history of the Supreme Court? The strangest thing that ever happened in the history of the Supreme Court. I can't tell you the name of the case, but there was a time when the Supreme Court was the trial court for a criminal case. So there was one time when they did a contempt of court at the United States Supreme Court, and they themselves heard the case because it was in their own court, and they acted as the trial court. And fortunately for everyone, the person who was being accused did not choose to have a jury, or was unaware of their right to choose a jury, because I'm not sure that they had, but they didn't get a jury because it's a criminal case, your right to a jury. So I don't know where you're going to stick 12 jurors, but that would be one hell of jury duty, right? Can you imagine that? Jury duty at the U.S. Supreme Court. So there's one time when they actually had a criminal trial at the U.S. Supreme Court for a contempt, and then they decided to never, ever, ever do it again, which is probably for the best. So these days, if you make an ass of yourself in the U.S. Supreme Court, they're going to try you at a different court. So you can still be held in contempt. They're just not going to try you at the U.S. Supreme Court. So that's probably the strangest thing that ever happened, was that. There's also some times where some people didn't show up for some cases. Most notable case probably is U.S. v. Miller, dealing with the Second Amendment case. So U.S. v. Miller is a very badly written decision. It's just not well written. It's very hard to read. And what was really interesting about it is that Miller never showed up in court. The case was argued by the U.S., and Miller never showed up. And so it was just the U.S., and that was pretty bizarre. And the case wasn't well written, and I think she's best just probably ignored, because it's a very difficult case, and it's very unclear what it stands for as a proposition. But that's pretty weird. Would SCOTUS have to pull jurors from the entire U.S.? Well, according to the language of the Constitution, a criminal jury should be from the state and district where the offense occurred. So no, because the offense would occur in District of Columbia, so the jury would be members of District of Columbia, presumably. But I don't know, because it didn't happen, and we don't have to worry about it because it will never ever happen again. Other things that are kind of bizarre, I don't know if it's bizarre or not, but there's a reason that time limits now exist for the 30 minutes rules, because back in the 19th century, there were no time limits, and some of the oral arguments at the Supreme Court would go on for days, 3 days, 4 days of oral argument on the same case. So at some point, someone decided that was a stupid idea, and they put in rules about time limits, and now it's a half hour each. So, so that's pretty bizarre. Nix v. Hayden, whether they argued whether or not tomato was a vegetable or not, whether it's a fruit or a vegetable. Yeah, that's a good case. I like Nix v. Hayden, whether or not a tomato qualifies as a fruit or vegetable. Supreme Court says it's a vegetable, notwithstanding the fact that it technically, biotanically counts as a fruit. For the purposes of law, a tomato is a vegetable because everyone thinks it's a vegetable, so we're going to pretend it is a vegetable. So it's a vegetable as far as the law is concerned, even though biotanically it is a fruit, but we don't care. We're the Supreme Court, it's a vegetable, go away. So that is pretty good. So wasn't there a lawsuit named Satan and the Staff? Yeah, sure. There's been a lot of cases where someone sued God and or sued the devil. Not the U.S. Supreme Court, I'm pretty sure, but definitely in trial courts, people have sued God and or Satan. Yeah, Justice Roberts made sure no one got a questioning there earlier. I mean, the red light had long since gone on, and that is one of his roles as Chief Justice, basically saying, yeah, we're done now. So that is one of the perks / roles of Chief Justice is to do that. So he was not out of line, but yeah, it's fine. Yeah. Saying no to a Scott's case would be a career killer. That too. And also, it's just like, why would you ever like give up the chance to do it? And they always find like really, really good people. They're really, really experienced Supreme Court lawyers. They're not picking me. They're picking someone who's been there many, many times. So, yeah. So yeah. So I think that was a really interesting case. If they get to the merits, 7-2, maybe they'll say harmless error. Maybe they'll give it back and say do some more sentencing. Not that I think it's going to matter because he's going to jail forever. He's never getting out of jail, nor should he. I mean, again, boys will be boys, but multiple serial murder is a bridge too far. I'm not. That's too much. I don't think there's any court that's going to look at that and be like, oh yeah, he's redeemable. No, I don't think so. So that's all for tonight. I hope this was a lot of fun. I had a lot of fun. We will probably do something next Friday with whatever cases are being decided. December the 2nd is the New York State Pistol Association Second Amendment case. So we will definitely listen to the oral argument for that in the week of December the 2nd. So I'm looking forward to that, and we'll see. Thank you all for all of you who turned in. I had, 27 of you are tuning in right now, as a matter of fact. So I seem to, every time I be doing these things, seem to be gaining some ground. And it seems like I'm gaining some people watching it, and I really, really appreciate it. The fact that you're watching me and that I'm able to do this is very validating to me. And I can get a lot better as a teacher. I've only been doing this for a couple months regularly, but I feel like, I'm making some progress in figuring out how to effectively do this and present information. And I feel like I can only get better. And so I'm pleased with my own progress. I feel like I have a lot of room to grow. I'm nowhere near my limit in figuring out how to effectively present information, but I feel like I'm getting better, and I feel like my edits are getting better, and my channel is growing, and people are tuning in. So it's very, very validating, because I figure, you give me a couple more years of this, I might actually be pretty good at it. So we'll do it. So there. So, and you got a knack for communicating to non-experts. That is the goal here. That is really what I'm trying to do. I'm really trying to talk to an audience. My working assumption is college educated, but no specific legal training. So all I'm hoping for is that you have a broad, general college education in something, so that I can talk to you on that kind of level and try to bring the legal stuff down into an easy to understand principle. And so I'm glad to see that. Someone asked about do harmless error and say it doesn't set a precedent? Oh, sure. Yeah, I think that's a very obvious avenue to say it's harmless error, and because it just doesn't matter either way. But if you're going to do that, why not just dig it anyway? Why bother? Why not? Because the only reason there is because this state lost at the level below. So if you dig it, then he does get his thing. So you might vacate it and do some other things. So I guess digging is not likely because Malvo won at the last level below, and they're not going to dig it in that light. So they're going to overturn or vacate. So they're either going to reverse or they're going to vacate. And I don't see a vacate because there's nothing obvious to vacate in light of. So they're going to reverse, or they'll do the 7-2 and say, yeah, you're right, but it just won't matter. So maybe they'll do 7-2, say, yeah, you win, but for all the good it's going to do, you go back and do another sentencing hearing. So yeah, maybe they'll affirm 7-2. That's actually my bet, is they'll affirm 7-2 and say, yeah, you're right. Do another sentencing hearing for all the good it will do you. And some trial judge somewhere is going to take about 10 minutes looking at it, be like, yeah, it's fine. All the previous testimony is still valid. It's not like the testimony is invalid. So you don't have to swear those people back in. You can just read the testimony back in and be like, okay, well, given everything, I'm just going to read it on the record and look at the factors and end of analysis. It's not going to take me very long. So let's see. Ill propaganda says I'm on point, no question. Hey, man, thanks. Juan says, I found out about me from Rakita Law. Thank you, man. I didn't know Rakita mentioned me. I know someone mentioned me on a stream, but did Rakita himself actually mention me, Juan? I know someone mentioned me on his stream, but did he himself actually mention me? Because I don't know if he's aware of my channel personally. I mean, I've covered the Vic Mignogna case, so he might well be, I would imagine, but I never heard him actually explicitly say that. Did he actually like analyze what I said about Nick Mignogna and say like either he agrees with me or I'm full of crap? Mentioned by one of his members. That's cool. Yeah, I'm not big enough for him to take mention of yet. He seems like an interesting guy. He seems like someone I would tend to get along with pretty well. So, you know, if we ever have the opportunity to talk, it could be fun. So, you know, it'd be interesting to hear what he had to say about the case in greater detail. I know that they're going to appeal. I look forward to reading their appeal and seeing if there's anything there. I'm not seeing any obvious issues so far, but that's what appeals are for. Someone else can file them and we'll read them, I guarantee you, and we'll see what there is there. But thank you for saying I seem to be succeeding in my goal. Thank you. All I want to do is become a better teacher. And so that is part of the exercise. And it's like, if the academy is anywhere people want to learn, it's like I have 27 people watching me. 27 people is a law school classroom. I have as many people watching this live as I would in a law classroom. And in the amount of people that are going to watch it over the next couple of days, if I get up to 200 watches, which is not out of the question. I mean, you know, I was pointing this out to Leonard the other day. I'm like, you have 100,000 people on your subscribing to you, Leonard. You have 100,000 people subscribing to you. If you have 1% of those watching a video of yours, that's 1,000 people. 1,000 people. Do you know like how many law schools worth of people that is? How many law schools worth of people 1,000 people is? I mean, that's a lot. So it's like, you know, it's just a message to be kind of grateful for what you have and grateful for the opportunity. So it's like, you know, the fact that we seem to be doing something is making some progress. Minus the gunners, well, we all learn. Gunners aren't so bad. For those of you who don't know what a gunner is, it's a law student who's desperate to impress. It's someone who is a teacher's pet. It's a specific name for a teacher's pet at a law school as a gunner. Yeah, we have special terms for them at law schools, but it's a teacher's pet. Anyways, I'm going to sign off. I really love you guys. Look forward to seeing you all later soon. Peace and good night.